September 21, 2012, this is Justice Dunder Cheap at the so-called Justice Building. Hello.
Hi.
How are you doing today?
Doing good.
Would you like to do an interview?
Yes.
So, what are your names?
Sally Brooks. Jen Womble.
So, you just sat in on a hearing, is that correct?
Yes, a bylaw infraction. Riding a bicycle on the sidewalk.
Wow. And was there anything notable that occurred during this hearing?
Do you want to kick off?
The police officer on the witness stand claims that they do not have any training manual, or they don't have it to know the law.
But yet these are the enforcers of the law.
Yes.
And it's logically hard to understand. How can someone enforce the law without knowing what the law is?
And one of the questions was about what gave him the powers of arrest for this bylaw matter that escalated into something else because he instigated physical violence against the alleged accused. I find it interesting. He said they have no training manual, because I've been sent an excerpt from the Fredericton Police Force training manual entitled Fredericton Police Force training notes or whatever manual, and it actually defines their powers of arrest, which Constable Beck couldn't describe.
He wasn't aware that they even had such a thing, it appeared, because he was clearly questioned, do you have a manual for such things? And he was unsure. He didn't see one, and it was clearly asked of him, are you trained? You know, if you're trained, what is it with? And he said, basically, we're just verbally told some stuff.
Yes,
Now, he's not sure what exactly it is.
I was at a hearing where another cop gave evidence under oath that the Fredericton City Police Force have no policies for training purposes, but they actually train their officers according to the actual applicable law.
And case law.
And case law. And today we got Mary Jane Richards saying exactly the opposite, interjecting to stop Mr. Murray from his cross-examination line of questioning, which was asking this officer what law allows you to do that.
Yes.
And as he says, that officer is an instrument of the law and an enforcer of the law. The judge interjected to say, you're not allowed to ask him questions about the law. He's not a lawyer. He doesn't have to answer those questions.
He doesn't have to know the law.
He just has to describe why he arrested you.
He just has to enforce the law, this mystery. He has to enforce the mystery without knowing for sure what he's enforcing.
He's going to describe his actions.
He's the legislative arm of the law.
The enforcement arm.
Enforcement arm. So, shame on that judge. Shame on the Fredericton City Police Force yet again, turning officers out to pull people off their bikes, actually running them off the road and then charging them for cycling on the sidewalk.
Yes, that is interesting. And then what was interesting is, as well, is there's about 30 to 40 people a day who get a 9:30 appointment to be here, and if they're not here, there can be warrants issued for their arrest. Yet everyone shows up, then we have to wait in line to have our matters heard. And we were here bright and early this morning at 9:30. They said, come back in 20 minutes to half an hour to an hour. We don't know. Just wait around for us to decide to pull you in. Then there was finally an adjournment, and then when we were brought back in, we were told, don't come back till 2:30 because we've got other things that are in priority. So just come back then, okay? And of course, we come back to almost an empty courtroom, and at 2:30 we started this trial.
And that was an empty courtroom.
Yes.
And I think that was the agenda, because Justice Mary Jane Richards knew one of the very awkward matters that would come up is that every single bylaw ticket infraction is commenced in court by the wrong documentation and the wrong process. It's commenced by laying an information instead of, under ticket procedures, a notice of prosecution. And that is the provincial law. You are issued a ticket, you're also issued a notice of prosecution. It says that in the Act from Section 9 onwards under ticket procedure. And Mary Jane Richards said, well, every single bylaw matter is commenced by laying an information.
Yes.
Now
That's the way it's done.
What we know from reading the Provincial Offences and Procedures Act is criminal matters are started by way of information, because you can go to prison. Tickets are supposed to be commenced by notice of prosecution because you should not be going to prison. It's not a criminal offence. So she is now commencing bylaw and ticket matters as as criminal offences, which means somebody can go to jail for not putting 25 cents in a parking meter.
So just that simple procedural error has some very serious consequences. And
yeah, we have a
life-changing.
Life-changing. So now we have, because we know when you go to prison, you've then got a criminal record for not putting money in a parking meter. So now we have a judge admitting on the court record.
yes,
She is actually blatantly using the wrong procedure. She's denying all knowledge of the ticket procedure and that it has any relevance in this court. Well, if it has no relevance, why is it from Section 9 onwards, so it's around about up to Section 20 or something?
titled ticket.
Entitled ticket procedure.
In great detail.
So which tickets does it apply to?
Yes.
Not bylaw tickets, not motor vehicle infraction tickets, no tickets. So why is it even in there?
And what was great is while Constable David Beck was on the stand, he confirmed he doesn't even know what a notice of prosecution is. He's never heard of one. He doesn't even know a date is supposed to be on a ticket, and the notice of prosecution is supposed to be served with it on the individual for stating the date of the trial. It was just amazing to me that to have a police officer, a constable, admit that yes, I have no idea what you're talking about, and to admit I haven't read the act.
He hasn't, because
And I'm not required to.
he's doing this the way he's been told to do it, and this is a problem that starts with the government in New Brunswick and filters all the way down to the police officers on the ground who are doing it wrong because that's how they're told and required to do it. Wrong.
Yes.
But what we saw today also shows that judges don't have to follow policy or procedures either. It's not just the Fredericton Police Force.
They can buck the law.
They can do whatever they want.
What's amazing is what people need to understand is a provincial court judge has no jurisdiction except a jurisdiction that can be clearly pointed out. That's opposite to a superior court judge, like a Court of Queen's Bench judge, where it's assumed they have jurisdiction unless it can be shown otherwise. So if the judge is going along with a procedure that was not even initiated according to the Act, they have no jurisdiction to even make a decision on it. They're nobody. And then for the police, and this Constable David Beck admitted that he's always used the same ticket book, never even heard of these correct forms, doesn't know what it is, never filed one, and it's very clear in the Act. It says under tickets, it says it must be filed by the date of the first plea hearing, or the procedure is not correctly started. I mean, it's plain English, well, legal English, but anyone who wants to go look at it can look it up. Provincial Offences Procedures Act.
Constable Beck was very clear that he has been authorised and required by his employers to manhandle people, arrest them when they're just riding a bicycle.
He also implied when he was asked if he used the same ticket book, he said in his job at Fredericton. So
yes.
It's possible he might have been trained and working in another police station in another area.
I didn't catch that. Wow.
So what's interesting about this case is it has three facets. One is just the general procedural aspect, as in this was started with the improper paperwork, the wrong statutes were used, as in not the correct portions of the statutes. The court doesn't have jurisdiction. And then the other aspect is the charter challenge. This city bylaw is constitutionally invalid, or should be deemed constitutionally invalid because it's discriminatory. One should be able to choose where they go, when, with a bicycle, as long as they're acting safely and not endangering others. And what was admitted on the stand today was that there was no one on the street. See, people don't realize that Constable David Beck's testimony in front of Judge Mary Jane Richards was simple. When the only way he was able to clearly 100% identify the defendant was when he pulled onto Aberdeen Street, and coming behind the defendant, he claimed his lights were going, his siren was being sounded, and this individual in front of him pulled off the road and onto the sidewalk. Then the story goes that they decided to apprehend the individual for obstruction of justice and for this ticket, this bylaw of riding on the sidewalk with a bicycle. So the only reason it appears that the individual went onto the sidewalk was to get out of the way of an emergency vehicle, which allegedly had sirens going and lights flashing. Everyone should do that, it seems. So, okay, they just created a situation where someone gets off the road to get out of the way of an emergency vehicle, gets punished for it. And then they say there's obstruction of justice going on, and then the story kept changing as well. It was interesting because he wasn't even able to identify the bicycle or the color of the bicycle or any relevant details. He just was looking for some guy in a blue bandana on a bicycle, and he originally came after the individual because he claims to have seen another individual at 3 minutes earlier. There wasn't even a direct correlation between the original sighting and the actual arrest. So he couldn't confirm 100% that it was the same individual. Yet he wanted to assert it was because that's what his story is based on.
Yeah.
To admit the truth that he's not sure and doesn't even know, it would collapse the whole case.
Yeah.
So he's asserting it to the end, which is unreasonable.
I know. What else is interesting is that we arrived there around 9:50 this morning. Constable Beck was already there. The city lawyer that they're paying, they hired him. He doesn't actually work for the city, he's hired by them.
George E. Kalinowski.
Mr. Kalinowski, he was there 9 o'clock, 9:15, whenever he arrived. And they just left at 4 o'clock, gone 4 o'clock this afternoon. And the entire day was spent funded by the city of Fredericton for a $50 ticket.
Yes.
And this is not the first hearing. This is one of many.
Yes.
The judge has had a lot of documentation to read, charge of violations. She was already made aware.
There was motions.
Prosecution wasn't issued, therefore there was a defect in proceedings. But they've kept on going.
There's even motions challenging the jurisdiction of the court because of the interaction that occurred on that day, which were dismissed. And then there was an application for judicial review, which was filed and has been lost in the paperwork in the courts. That still hasn't come back to light. That was filed in January. We're now September.
And I have no doubt if when she comes back and says guilty is charged, pay a $50 fine and pay your $50 ticket and a fine.
Yes.
Then you can appeal, and it takes up more judges' time and lawyers' time, and for a $50 ticket, and judges and lawyers and police who aren't even applying the appropriate law.
Yes.
It's miserable.
It's inescapable that they're not even using the correct portion of the act. If they're not using the law to apply the law, then what are they doing? They're acting lawless.
Yes.
And the consequences to all of us is we can be facing jail time.
Yeah. And Mary Jane
Many
sat
of us
there,
have.
as we said, she sat there and she said, well, every bylaw matter is commenced by laying in information according to Section 2 of the Provincial Offences Procedures Act. So she's created common law that means she can completely ignore and disregard the actual applicable sections of that act.
Yes.
Unbelievable. But of course she's been doing it as long as she's been a judge. So she can't suddenly say, ooh, I did it wrong. Because every single person has had it done wrong. Who's had an information laid for a bylaw matter.
And I think it was important too that I stated, well, maybe you've done it up to this date, but I'm not going along with it. I do not consent to go along with erroneous procedures. And whatever everyone else is doing, I'm not doing it. Maybe I'm asking for special treatment, being actually treated lawfully and correctly according to the law.
That would be unusual in Fredericton.
Yes. So, all in all, any final thoughts on today?
I think what got onto the record today was very important for every single person who's been through a ticket procedure that's been wrongly done. The thing is to just get it out there in the public domain, and I would say anyone who watches this video, finds out, spread the word. It's not being done properly.
Yes. We have a right to proper procedure. If we're being dragged in there under threat of warrants and all kinds of negative experiences, especially with the improper paperwork allowing us to be brought into jail, I mean, it's just unbelievable. So hopefully we're making a step in the right direction today.
Yes.
I think there was lots of great information put onto the record, lots of interesting questions going to the police officer, Constable David Beck. And what was interesting too is the judge did not want me to allow too much background information to be put onto the record, because Constable David Beck actually, knew me from an incident that happened before, and as soon as I started describing the incident in detail, she jumped right in there and said, no more of that. We're not talking about these other facts that may be terribly relevant.
Yeah, well, she didn't want it established that Mr. Murray is very distinctive looking, and Constable Beck would have had no problem identifying him from a great distance.
Yes.
Bandana or not.
Yes.
He knew exactly who it was. He was
so,
having spent an hour in his house.
Yes.
Uninvited.
Yes, and watching Mr. Murray have a lively debate with the police, asserting that they had no right to evict him in the first place based on improper paperwork and a non-existent order to vacate someone, it would leave an impression, I am sure. It doesn't happen every day unless it does, and we'd love to hear those stories. So everyone else finds out, we got to put a stop to these rogue procedures, rogue police that are acting inappropriately. And I mean, how is it too much to ask the judges, the police, and the prosecutors to act according to the law?
Well, I think the problem is
In Fredericton.
they're so entrenched in doing it wrong, you can't suddenly do it right. Because people who have had an information issued against them for a simple ticket instead of the correct notice of prosecution, if they suddenly stop doing it wrong, they've set a precedent and admitted it.
Yes.
So the floodgates would open for people to sue them.
Yes.
Big time.
Yeah. So we need to get the information out there.
All right. Information about them laying informations, which is wrong. All right, thank you for that. We'll land on that high note. Have a great day, ladies. Justice done dirt cheap at the so-called Justice Building, Fredericton, New Brunswick.